Good afternoon. Mark Aiello on behalf of the appellant. This is a case that involves entry of judgment, actually two judgments, in cases in which the appellant had been previously named as a party, but had moved for summary disposition and had the particular claims dismissed. So in other words, the plaintiffs in the 2009 cases had brought 3 claims against the appellant. The relevant ones here are the UFTA claims. The appellant had moved early on for summary disposition under C-8 on both claims. The court had granted the motion for C-8. About a year and a half later, the court had a trial on a remaining claim against 2 other parties. There was an 07 case, and I'm not going to get into all the detail because I think we've stated it very clearly in the briefing. But in that case, the court, in the dismissal case, which was a 2007 case, actually it was a dissolution case, the court had issued an injunctive order.
Are you of the impression we don't know what the facts are?
Pardon me, Your Honor?
Are you of the impression the court doesn't know what the facts are?
No, Your Honor.
I would get to the
Okay.
questions that you think, if there are facts that you think are relevant to your outcome determinative issues, fine, but get to those.
Okay. I think a couple of items are important that I should stress from the briefing. The first is the lack of due process. I think it's very important to note that the counsel for the appellant at the outset of the hearings, and they were not consolidated cases, indicated and made clear that he was appearing only in connection with the show cause hearing on the 2007 case. The court agreed with that. I think it's very important to note the distinction between a trial on causes of action and a show cause hearing.
You spent your first 2 minutes talking about facts. Now we get to talk about what I want to talk about. You postured this case as a due process case. I want to suggest to you this. I'd like to know, well, let me ask it directly. What process, had you been rejoined when the clawback question was being addressed by the trial court, what process, what additional process would you have gotten that you didn't actually get here?
A number of things, Your Honor. Number one, there was an amended complaint filed in March of 2010. It was stipulated to by the parties in which the court ordered that the amended claims and parties have been dismissed and only included such claims and parties in the second amended claim in order to preserve the rights on appeal. So in other words, my client didn't respond to that as the court had indicated that they were just being named for preservation of appellate rights. My client, if those claims had been pending, given a reversal of earlier summary disposition, would have requested a jury. Okay? Under a show cause hearing, and being present in a contempt hearing, they had no right to a jury. It was an equitable hearing on injunctive relief. If there had been a cause of action under the UFTA, and when that second amended complaint was filed, my client would have, A, requested to be tried in front of a jury. Secondly, my client did not have discovery. It was a subject of third-party discovery, but it did not conduct its own discovery. So between the...
Were you precluded from doing it? I was under the impression that the trial judge said you could have it.
No, the trial judge had dismissed our party. Well, we were no longer a party to the case.
I understand, but for some reason, instead of saying, no, thank you, we're not a party, we're not participating, when directed to participate by the trial court, you did. My question, therefore, is, I mean, you almost extraordinarily the amount of participation in this for a party who claimed it was not a party.
Well, not really. My client did not have much participation between the dismissal of the actions against it and the contempt hearing, which was a year and a half later. Okay, the other parties to the case issued deposition notice and issued a subpoena for documentation. So documentation was sought from my client, and depositions were taken on my client. My client was no longer in the case. It had no power to issue a subpoena as a non-party in the case. It had no ability to issue notices of deposition or other discovery. It was no longer a party in the case.
I understand that, but then you were directed to participate in this clawback proceeding.
No, we were directed to participate in the contempt motion, not in the clawback decision.
All right.
We were
So
not.
you didn't participate in
There
that
was no subpoena. We were never subpoenaed in the 09 cases. We weren't there under court process. Okay? We were only brought in under the contempt case, which was the 2007 case, which are fundamentally different cases. If you go and show up in a contempt motion, a show cause hearing, so we were only there for that, okay? That's a claim that a judge is going to determine whether or not you violated a court order, okay? And the proof is in the pudding, because what did the court do here? It found us not in contempt. So they can't be similar type of hearings or proceedings, because the court said you're not in contempt on the show cause. But then in the 09 cases, issued judgments against my client.
Well, can I ask a similar question to what the Chief Justice just asked? Not what additional due process you might have enjoyed under different circumstances, but had you known from the very beginning what the stakes were for New York in this case, which were arguably much greater than you had been initially told by the court, but if you were fully aware of what the stakes were in terms of your interests, might you have pursued a different strategy in any respect? And if so, what might that strategy have been?
Well, we would have definitely had a different strategy, because on the contempt motion, if the judge finds that you violated an injunctive order not to transfer assets, the judge's recourse would have been to unwind the transaction. In other words, give the assets back. Okay? In a contempt hearing, the judge could not have issued a judgment for money damages against you. All right? So very significant difference in strategy. Okay? We would have asked for a jury. We would have taken discovery. The remedies are different under a contempt motion or show cause hearing versus a cause of action in a case. There would have been very, very significant differences in what my client would have done, especially in that 1.5 years from when the case was dismissed with prejudice on summary disposition against my client, and then it was brought before the court on a show cause hearing, not in the 09 cases for which the judgments were entered against it, okay, but in an 07 case. And I think it's very significant that the court entered the summary disposition and dismissed with prejudice the very claims on which it entered judgment.
That's not accurate, is it?
How is that
summary
different?
dispositions, I read the orders. There are direct causes of action under the Unfair Trade Practices Act, and then there's the clawback provision. The court specifically cited the direct causes of action under the FTA. The ones that are at issue in the clawback were not dismissed or discussed. Isn't that accurate?
What the court, Section 34, which is the fundamental basis on which the UFTA belies, those direct claims were brought against New York Private Insurance Agency. Those were dismissed. The clawback provisions can be enacted under 3738 of the UFTA if there's a finding against the party on the Section 34. But those were never claimed. They were never alleged. They weren't in the original complaint.
I believe Judge Yates indicated that the clawback remedy remained in play. Is that not true?
He said that, but they were not the subject of a complaint. There was no complaint against my client for which those claims were made.
Is there a right to a jury trial under the UFTA?
Yes.
Where? What section are you relying on?
Well, I don't know if there's a section that says you're right to a jury trial, but there's no prohibition on a jury trial. It's a money damages claim. I requested juries in UFTA claims before.
Why should we assume that you only became aware of the true stakes that were involved for New York after judgment was entered, when you've got in black and white in that clawback provision the exposure that you might be facing in a case of this type?
Because you have to have a complaint filed against you asserting a clawback, okay? You have to be named in a case as a party. A claim has to be made. It says we are seeking a claim against you under this provision of the UFTA. And that was never made. There was never a pending claim against my client under that section of the UFTA. Preliminary or other sections of the UFTA were subject of complaints against my client, and those were dismissed with prejudice. Okay, it's the plaintiff's obligation. If the plaintiff is going to say, "I'm going to assert a claim under the UFTA against you under this particular section," then they have to bring that in the complaint. Or if the claims they had made were dismissed with prejudice, they have to move to amend their complaint to bring you back in as a party and assert those particular claims against you. And then you have the right to either request a jury, you have a right to conduct discovery, to depose their witnesses, to depose their experts, to file motions in limine, to issue third-party subpoenas, all the things that our justice system enables a party against who a cause of action has been claimed.
I'm still intrigued by this right to a jury. We decided a case not long ago on whether there's a right to a jury, and I'm looking at this statute, and most of what it talks about, almost all of it, has to do with equitable things. In fact, it says subject to applicable principles of equity. The court can do one or more of the following: enter an injunction, appoint a receiver, any other relief the court determines is appropriate. How would the jury decide what relief the court determines is appropriate in a case?
Well, in this case, for example, the court determined...
the money damages is simply the return of the asset. That's right, the return of the funds that were transferred or other asset that was transferred in violation of the act, right? Right.
Here the court made a determination of what the value of the business was and entered a judgment.
Is there any provision that says the words money damages in the act?
I don't have it in front of me. I don't know. That's the true answer.
So let's set
I know it allows a judgment. I don't know the
all right,
so let's set aside that question. If it's not, you said if we had been named, we would have asked for a jury trial. Let's set that aside.
Yeah.
How else were you harmed? So
we didn't get to conduct discovery.
So it's discovery. So if we put aside the jury trial, you think that your claim of prejudice rests on the discovery issue?
No, and a strategy. I said earlier we would have had a completely different strategy. Under a show cause, okay, the remedy would be if you violated the injunctive order for prohibiting the transfer, it would have been to unwind the transaction. Okay, under a show cause and a contempt, there wouldn't have been the ability to enter a money judgment against the party. There would have been a very different strategy in the case. Not in addition to discovery, and not only discovery, but pretrial motions. We didn't file pretrial motions. We would have, I'm sure, would have filed some motions to eliminate, because now going back and looking at some of the things that they would have objected to, and I don't know what the outcome would have had been. And that, same as I don't know what the outcome of all discovery. We would have deposed and had depositions.
But could it not be argued that
without having ever had that opportunity to do so?
But could it not be?
I'm sorry, Justice Brent.
No problem.
Assume that your client does not have a right to a jury, or at least that issue has not been preserved in this case. Would your client, if we were to remand this case and it was a bench trial, could some of these issues be addressed on a remand without granting an entire new trial? For example, the court could allow discovery or could address some other legal arguments.
The trial in the case had different parties involved. We weren't in the 09 case. It was against MSG and it was against CNH.
You say you weren't in it, but your client was there and was represented and participated and, in fact, led much of the questioning and cross-examination, correct?
It led.
I mean, the main issue.
I don't know how to characterize it, but it certainly was there, as it had clarified in the 07 proceeding. There was not ever a statement from the court that said that you're here in the 09 proceeding.
The main issue between the two cases was pretty much the same, right? Whether the asset was transferred for fair value.
Well, no, because my client was there on a show cause, which was, did they violate the court order?
So your client never argued that issue in overcoming the...
It argued a number of things, but again, they were different. The court found that my client was not in contempt and had not violated a court order. So certainly the standards between a show cause and a cause of action are different because we were found not
that
guilty.
wasn't my question. I was reducing it down to the essential issue that I think was in common between the two proceedings, and you're sort of dodging that question. Was there not a common issue between the two proceedings, or you're saying there was a bunch of other issues too? Okay.
There's a bunch of other issues, and again, the strategy would have been different because we would have handled it differently if it was a case for money damages and a money judgment. We would have adjusted the Article 9. We didn't adjust Article 9. Okay, I know one thing they would have had an expert, because in this case it was a credit bid with the assumption of secured debt, okay, which is not uncommon in an Article 9 matter. And if you do a lot of bankruptcy work, you know that you can make a credit bid, you can assume secured debt, and cure trade creditors, which is kind of what happened here, but in the state setting under Article 9.
You're saying if your client was held in contempt, he wouldn't have been ordered to return the asset?
If he was found in contempt, he would have been ordered to return the asset. I'm presuming that that's what the court.
The asset was money, so that's different than a money judgment. How?
No, the asset was not. The asset, my client did not receive money. The asset was this is an insurance agency. The asset was were customer accounts. That's the asset.
All right, I see.
Customer accounts. My client purchased from C&H, who had
Thank
Article
you.
9.
Actually, Chief, can I just
Yes.
a quick question?
Yes.
Just the question I want to ask, could it not be argued, though, that your current posture, going back to your strategy discussion, could it not be argued that the current posture that your client took was, in fact, a strategy decision?
I'm sorry, Justice.
Your client's posture in this case was entirely strategic? That's the question. Could that not be?
I think there was some. I think as counsel, with respect to any client, your posturing is strategic, and you're looking at what's the nature of the claim that's against you, what are the potential.
Right, but I think Justice Bernstein is asking whether you sandbagged. So when the trial court said, hey, you might be liable for the clawback remedy here, you said, well, fine, he's forgotten that we're dismissed from the case, we'll do nothing, and then we'll come back and we'll spring it on the Supreme Court. I think that's Justice Bernstein's question.
No, not at all, because
Isn't the time to make the argument we're not a party at the point you are starting down the clawback trail? Your client was in the spinach up to its fetlocks at that point, and you chose to go forward. Rather than drive home the point, you can't do this, we're not a party.
No, we did. At the very first hearing on June 3, when we were brought in under a show cause order, the counsel, who Mr. Gerling on behalf of the appellant, had said, and I cite different testimony here, in my brief, especially in my reply brief on pages 3 and 4, some of it. And Gerling said that we're here to show cause relates to the 07 case. The court said, correct, right, you're out of the 09 case for once, for all, and forever. Mr. Gerling said, all right. The court said, okay, thank you. Also on that same day in that discussion, Mr. Gerling had said, we're certainly not participants. We were talking about coming into the proceeding under a show cause, that we weren't participants in any meaningful manner, and the discovery phase has gone on far too long, and all this came up, and the court then responded, again, because he was saying, I'm here on the show cause in the 07 case, and we haven't been involved in the 09 case in some time. And the court said, you're not in the 09 case, you're not in the 09 cases.
Didn't the court at that point say, but there's still the clawback issue at that very hearing?
I don't believe it was on the June 3rd hearing.
Okay.
But I don't have all those hearings in front of me. I mean, it will be what the record reflects. I honestly, I don't think it was, but I don't know for.
Thank you. Your time is up.
Good morning, Your Honors. May it please the Court, Stan Steck appearing on behalf of the appellees. The gravamen of the claim here to the court is that a deprivation of due process occurred here. This court has affirmed time and again that due process is not a rigid, fixed set of regulatory rules. It is a flexible, fluid principle that bends and morphs depending upon the contours of the facts of a case. Now, we submitted briefs that identify what are a fairly complex set of contours in this case, which we have asserted identify that there was a notice that the assets were subjected to the clawback remedy, that they had an opportunity to be heard on that issue, and in fact they were heard fully on that issue. Now, apart from that, there are three key factual components that I think that can decide this case. The first goes back to the point where that first order granting summary disposition was issued back in October of 2009. At that point, the court identified that it was just the direct cause of action that we had pled under 3.1a of UFTA that was being dismissed. Now, it is a ruling that's interlocutory, and so under the MCR 2.604, it remains subject to the right to be revised. And in fact, it remained that so until the final judgment was entered in 2012. Now, within weeks of the ruling on the motions for reconsideration, in March 19 of 2010, a wide conversation took place with Mr. Gerling, counsel for New York Private President, in which the question of the clawback remedy, still being an exposure, even though the direct cause of action was dismissed, was discussed. And it was openly stated by the court, look, I have not resolved that issue yet. That's not been resolved. In fact, he talks in the context of you essentially are a party until that's resolved. Now, Mr. Gerling didn't like that, and he protested, and he even talked about maybe bifurcating the process. But at no time did he assert that that's not the case. In fact, he filed affirmative defenses.
Counsel, this is a factually dense record.
Yes.
And I certainly can understand how a trial judge with this kind of record and the intensity of the lawyering could lose his place. But the fact of the matter is, in I think it was 2009, I'm not sure, there were 2 or 3 orders of dismissal, all dealing with the direct causes of action.
Correct.
And he appears to have thought, because that's what he communicated, that he dismissed New York as a party.
Correct.
Well, isn't that a problem?
Well, for purposes of what the issue is here, you have to look at the court's discussion of that.
Ordinarily, we have judges acting for or against parties before.
That's correct.
Okay. So now explain to me why that normative process, which didn't occur here, your client never moved to rejoin New York as a party, correct?
That's correct.
Everybody just sort of proceeded as though they were.
Well, I think that's the key issue.
And
Everybody proceeded as if they were still a party.
Why is that not a problem?
Well, I think from a due process perspective, it's not a problem because they're on specific notice of what is the remaining issue. And it was articulated extremely carefully and clearly by the court on March 19 as to what is the remaining issue.
Trial?
Pardon me?
Is there a right to jury trial under this provision?
I don't think that there is. And I'd point out, even if there was, they were a party for quite some time before the motion for summary disposition. They never asked for a jury in this case.
Okay. So when they were a party, they waived it.
When they were a party, they would have waived it if there was a right. I'm not entirely sure that there is a right. So
if there is a right to jury trial, does that change the equation?
No, I think that it still goes back to the question of would they have had, if they had a right, they should have asked for it at the time of those responsive pleadings. They didn't do that.
Was the clawback provision in play before they were dismissed?
I think that the clawback provision was in play, but it was not articulated until after they were dismissed.
Articulated where?
Articulated on March 19 of 2010 when we had the hearing with respect to how far would the crime fraud exception to the attorney privilege be extended. And that's the conversation where we said, Judge, the question of the transfer from Sharon and Hanisch to New York Private is a key question with respect to whether or not it was taken for good faith and for value.
Right.
And so the judge looked at it and said, yeah, the clawback provision, I have not resolved that yet, and I'm not sure you're not a
Why
party
wasn't there
yet.
a motion at that point to amend the complaint to bring them back in as a party?
There wasn't.
And why isn't that a problem?
Well, I think it is a problem, except for the fact that they did participate extensively from the proceedings thereafter. So from a due process point of view, the question is, were they on notice that their assets were still subjected to a possible clawback? And I'm asserting that the court couldn't have made it clear in that hearing they are still subject to a clawback remedy. And what makes it even clearer is that they filed affirmative defenses a month later. And those affirmative defenses were specifically, this is after they've been essentially granted the summary disposition on the direct causes of action. They filed affirmative defenses in this case.
Which is an odd thing for a non-party to file a pleading.
Which is an odd thing for a non-party. But it acknowledged they know, because it specifically says, to the extent that our assets are being asserted as a claim of recovery, here's all of the defenses we're putting you on notice of, including the good faith.
Can I ask you another question?
Yeah. You're the judge.
As fascinating as this case is, with all of its eddies and nooks and crannies, this is such an unusual case. I have an expression, when you hear hoofbeats, think horses, not zebras. This kind of looks like not a zebra, a unicorn. My question is, why do we care about this case at the Supreme Court? What's jurisprudentially significant about it?
Well, my answer to that question, Your Honor, is I don't think that there is anything specifically unique that would call this Court's attention to this case. That is a incredibly fact-intensive analysis of whether or not fundamental due process was accommodated. The judge that lived this case for 5 years, an astute judge, concluded that due process was not violated. The Court of Appeals concluded that it was not unanimously. I think the fact-intensive nature of this case suggests that there's not an issue that suggests this Court should take this case.
Thank you very much. Case is submitted.